Good morning. Welcome to our live webinar, our general family law Q&A on various topics relating to family law. Today we have 3 questions, quite interesting as usual. The first one, the parties wants to get divorced, or at least the wife wants to get divorced from her husband. However, she lives in Cape Town and the husband lives in London. How does that divorce process work? The second question, the party wants to relocate in the near future. What advice do we have for that specific person? What does that person have to know, look out for, or how to plan ahead regarding consent issues? Third question, the parties want to get divorced by agreement. What is the fastest way of getting divorced? So quite general questions that you may find applicable to your specific scenario. If you have any questions, I'll be keeping an eye out on the Advocate Mohammed Abduroaf Facebook page. Please feel free to pose your questions and I shall try my best to answer them. Okay, let's begin. The first question. I want to divorce my husband. I live in Cape Town and he lives in London. We have 3 minor children. They all live with me. Where do I start? Okay, so let's apply the scenario to a situation should both parties have been living in South Africa. And then we apply it to the scenario where one party lives overseas, not in South Africa. Okay, should the parties have lived in South Africa, both of them, the divorce would have been quite simplistic in the sense the wife in this scenario would have gone to an attorney, a local attorney. The attorney would have drafted the divorce documentation, the summons, particulars of claim, and so on. The attorney would have issued the documentation at the relevant court, family court or high court. Thereafter, the attorney would have sent this documentation to the sheriff where the husband resides. It could have been possibly in Cape Town, Johannesburg, anywhere in South Africa. The sheriff would have served those documentation on the husband, and then the 30 days for the husband to decide whether or not to defend the divorce commence. Simple as that. Should he do nothing, the wife can proceed in the Cape Town court with the divorce on an unopposed basis. Should the husband, of course, decide to defend the divorce, simple, he'll file a notice of intention to defend at the relevant divorce court, and then plea with a counterclaim, etc., and the matter will roll. Now, in this specific scenario, the husband does not live in South Africa, he lives in a different country. Now, obviously, we do not have authority in a different country, in another country, and the rules of court that applies to South Africa does not apply to foreign jurisdiction. So, there is a process called edictal citation, whereby you can serve documentation on someone in a foreign country with the consent of the court first. So it's basically an alternative mechanism of serving documentation on someone else, should that person be in a foreign court or in a foreign jurisdiction. You can also ask the court that because of that you'd like to serve the documentation on the other party via email, via Facebook, via WhatsApp, whatever the case may be. But the basic concept would be that the person does not live within our jurisdiction, and you're asking the court for consent to allow you to serve the documentation on the other party via different means. It could be via the sheriff that side, if the country has a sheriff, via an attorney that side, whatever the case may be. So how do you do that? Basically, you draft your divorce paperwork, you issue it, etc. You approach your court, you advise the court, the other party does not live in this jurisdiction, he lives overseas. Give me consent to serve this documentation on him via email. Okay, the court says, wonderful, I give you the consent. You tried everything. If the person isn't here, what else can we do? The order will basically stipulate that the attorney for the mother or the wife in the scenario is allowed to serve it on the other party on the specific email address. The attorney will do that, and he will provide an affidavit afterwards to advise the court, I have served this documentation on the other party via email to the specific email address. He has responded or has not responded, that's something else. And then the time elapsed for the other party while he is overseas to decide whether or not to defend the matter or not. If he or she decides to defend the matter, wonderful, the matter proceeds as usual. He or she may obtain the services of an attorney locally, maybe in Cape Town, to file a notice of intention to defend and move the matter forward. So, long story short, the bottom line is a divorce where one party lives in a different country can still proceed. The only challenge you may have initially would be serving the divorce documentation on the other party. And you cannot automatically, by default, serve the documentation on the other party via email. If that was the case, then people will never go to sheriff offices. They will just issue paperwork at court and serve it upon anybody via email. But however, you would want to obtain the court's consent, and if the court granted you that specific consent, the process proceeds as usual. I hope that answered question number one's question. Or questionnaire number one's question. Question number two. I want to relocate to the USA with my children in the future. I have a family there. Or I have family there. I have two children and we are living in Gauteng. What advice do you have for me when it comes to consent issues? Okay, so this person is not necessarily planning on relocating in the future. There is no job offer, there is no actual plans to move, but the person wants to somewhere in the future relocate. And before that person embarks on that specific journey to start the relocation process, the person wants to know, what advice do I have for that person? Okay, first thing first, it would be good to obtain the consent of the other party first. That would make matters very easy, and if the consent is provided, there shouldn't be much issues. It should be straightforward. Basically, just getting documentation signed and consent provided, and so on. However, if the other party does not want to consent, of course, then we're talking about litigation and etc. But let us avoid that for now. Let us presume that you never ask the other party yet, and you're far from that point. You want to get your house in order first. With the relocation matter, the court would have to determine what is in the minor child's best interest. That's first and foremost. If you are the minor child's primary caregiver, the child primarily lives with you, of course, your case would be stronger, because the alternative would be to leave the child behind, and who will care for the child? Can the other parent care for the child? Does the other parent have the capabilities, the capacity, and so on to care for the minor child? So that's number one. If you are the primary caregiver, the case becomes a bit more easier then. But then the court would have to be satisfied that the relocation would be in the minor child's best interest. Obviously, the minor child will no longer have, regular contact with the father locally in Gauteng. The minor child would have to change schools, no longer see his friends, total new world. Whatever the case may be, London is a different place, a total different country. The educational system is different. Family members, of course, there are family members there, but they are not the family members the minor child is used to. So you'll have to do your homework and your preparation. Are there schools available in London? Are there medical facilities available in London that would assist, that will be beneficial to the minor child under the circumstances? Are you moving to an area within London whereby the busy, it's chaotic, I do not know? Or are you moving to an area that will facilitate the transition of the minor child moving from Gauteng to London? So those things you have to look at. Obviously, issues concerning hospitals, medical facilities, and so on. So you will obviously have to do your homework and explain now, okay, that moving to London is a good idea because everything is there and the facilities are there, and done my homework. I do not know what your child's conditions are, if your child has any conditions, but if the child has certain, example, learning disorders, those type of things, are there schools that can assist a minor child? So each family is different, each situation is different, and circumstances will obviously differ from family to family. And at the same time, how will you care for the minor child? At present, the father locally in Gauteng is paying, for argument's sake, let's say 5,000 South African rands. If you convert that into euros or to the pound, it won't be much because of the exchange rate. Do you have a job there? Now you move all the way to London. Where will you stay? Who will feed the minor child? Can you feed the minor child? Will you be working? Will your family be assisting? And all those things. So those are very important things to look at. What is a plan of action? Are you planning on going to London hoping for the best? School fees and so on. The father can only afford to pay the 5,000 per month. His salary is 15,000 per month. He pays a third of his salary towards the maintenance of the minor child. You are unemployed. If you are unemployed, why are you going to London? If you're going there and you have a job available and work available, a lot of savings whereby you can look for work, that's a factual thing. Where I'm going to with this is each case is different, each facts are different, all facts are different. I mean, no one is perfect, no scenario is perfect. There's always issues or certain hiccups which you can obviously try to overcome. The bottom line is you will have to make sure that should you relocate to London, that all your ducks are taken care of. All concerns are taken care of. If there is a concern, you should have a plan B, should a concern not be dealt with. So I hope I'm assisting you regarding that. Once you have done that, you've done all your research, you have gone on the internet, you got your web links, you got connected to certain people, you connected to the schools, you connected to the accommodation, and so on. And now you determine, okay, you know what, I want to relocate December 2022 or the end of December 2022 because by that time the minor child would be done with the school year and it would be the best time to relocate. Now if I said 2021 that would not work because we are blacklisted, red listed, and my apologies for that. But nonetheless you have a plan of action. Now you need to put your plan of action into progress. You've done all of that, you've done your research, etc. You've provisionally secured a job, provisionally secured a school for the minor child, etc. Now you approach the other parent and tell the other parent, you know what, I've done all of this. I want to relocate to the UK for better life for me, for better life for the minor child, for better job for me, and so on. Do you consent for us going? Here's the documentation, here's the information. It will be the minor child's best interest to relocate. His schooling will be attended to, his medical conditions will be attended to, whatever the case may be, and I'm ready to go and I want to go. What is your view and will you consent? If the other party says, you know, wonderful, I do consent because you've done what you have done and, you know, it's best for the minor child, wonderful, life goes on, sign the necessary documentation, great. If, however, the other parent does not agree to that, he or she says, you know, I want the minor child to remain here, what can you do? You have to approach the court, and the court would have to now make a determination as to whether or not it would be in the minor child's best interest for you to relocate with the minor child to London. The court will obviously have to listen to your side of the story, to the father's side of the story, and at the end of the day, the court makes a decision. It will be in the minor child's best interest to relocate with you to London. The court will make such an order, and basically the court will stipulate that the father's consent is not required for the relocation to take place. Now, with both scenarios, whether or not the father agrees to it or he disagrees to it, the ultimate idea, yes, if he agrees to it, he can sign a few pages and life goes on, but the ultimate idea would be to get a court order, a parenting plan made in order of court, or some document, some legal document dealing with the care and contact arrangements that will be in place should you relocate to London. For argument's sake, let's say you want to enroll the minor child into a school. Is it possible? Does it make logical sense that you can contact the father in Gauteng and he will immediately sign the documentation and send it over that side? Should the minor child need to go to the doctor or to the hospital and ask for the father's consent? Will that make pragmatical sense for the relocation to take place to London, but having the other guardian, the co-guardian, living in Gauteng? When it comes to consent issues, will it be accessible? Will it be amenable? Will there be problems, etc.? So therefore, I would suggest, even if the parties came to an agreement regarding the relocation, still approach a court to have some documentation in place stipulating that should the mother relocate to London, to the UK, when it comes to matters concerning schooling, passport applications, hospital consent, and so on, that under those circumstances only the mother's consent is required and not the father's consent is required, because it makes logical sense under those circumstances. But when it comes to a relocation to a different country, maybe under those circumstances the father's consent would be required. So that is my advice to you. To question number 2, please make sure you get your ducks in a row, because should the other party decide to disagree, more than likely he or she will disagree because you have not provided a very good reason, a sound reason why you wish to relocate in the near future. And if he or she does object to the relocation, at least you can show the court that you have done everything you should have. Here is the documentation, here is the information. It will be in a minor child's best interest to relocate with you. So that was question number 2. Thank you very much for that one. And the third question and the last question. Both me and my husband are in agreement to get divorced. What is the fastest way to get divorced? We have 2 children and married with ANC. ANC basically it can mean 2 things. But basically they're married out of community property, either with a accrual or without the accrual system, regime. I dealt with that in quite a few webinars in the past. I shall not deal with that now because the topic is basically how to get divorced. So if both you and your husband are living in the same province, in the same area, a divorce can be finalized in a period of about a month or 2, depending upon the court's availability to hear you because of COVID-19. They might be limiting the amount of divorces they do on a weekly basis, on a daily basis. Should you do the divorce maybe in the Western Cape High Court, divorce dates are not that far out, maybe about a month and a half, 2 maximum. Under normal circumstances, I would advise, before COVID-19, I could have thumb-sucked and said, the quickest way you can get divorced would be a period of 21 days. 21 days from the moment you entered into the attorney's office. The next day the divorce documentation are served on the other party. 10 days passes, the matter gets set down for finalization. So about 21 days maximum. Unfortunately, with COVID-19, court dates are a bit stretched out and it's a bit hard to get dates sooner than later. You'll have to wait a bit. But worst case, that could be about 2 months that you'll have to wait to finalize a divorce. So my quick answer to you would be, if you meet with an attorney today, you draft the documentation, you sign everything, you get served the next day, you wait out your 10 days, you apply for the court date. If the court date could possibly be in a period of 4 weeks, 5 weeks time, wonderful to get divorced in those 5 weeks time. That is my webinar for today. If you have any questions, I see you do not have any questions. We have a lot of viewers there online. But nonetheless, thank you very much for watching and I hope to see you online soon.